VA has just rewritten the rules on how medication affects disability ratings. And if you practice in this space or have a pending claim, this matters. Effective February 17, 2026, VA amended 38 C.F.R. Section 4.10, the regulation that governs functional impairment. The amendment was published as an interim final rule, meaning there will be no public comment period first. More on that in a few minutes. The new rule adds 2 sentences that effectively overrule 13 years of case law from the U.S. Court of Appeals for Veterans Claims. Here is the key change. Under the new language, examiners will not estimate or discount improvements to a disability due to medication or treatment. If medication lowers the level of disability, the rating will be based on that lowered level. So, in plain language, if your condition is better because of medication, VA will rate you based on how you function with the medication, not how severe the condition would be without medication. This rule change is VA's response to what practitioners know as the Jones line of cases. In the 2012 case of Jones v. Shinseki, the court held that the board errs when it considers the ameliorative effects of medication if the diagnostic code does not specifically contemplate medication. In other words, unless the rating criteria say to factor in medication, VA was not supposed to reduce a rating just because medication helped. Then in McCarroll v. McDonald, a 2016 case, the court used the word discount, reinforcing that VA could not discount symptoms because they were controlled by medication, unless the regulation clearly allowed or provided for it. Most recently, in Ingram v. Collins from 2025, the court extended Jones into the musculoskeletal context. The court required examiners to determine a baseline level of severity without medication. That meant asking medical professionals to speculate about what a knee, back, or shoulder condition, for example, would look like absent treatment. VA says that decision in Ingram would require the re-adjudication of more than 350,000 pending claims across approximately 500 diagnostic codes. That is not a trivial administrative burden. Now, the authority for VA to fix this through rulemaking is not really in question. The Jones court itself acknowledged that VA could amend its regulations if it disagreed with the court's interpretation of the rule. So from a separation of powers standpoint, VA can do this. What deserves scrutiny is how it was done and how the change is framed. Again, this is an interim final rule with immediate effect. VA's preamble to the change states that the rule, quote, simply makes explicit long-standing VA policy and practice, end quote. There was no prior notice and comment period before it became effective. But the Office of Information and Regulatory Affairs classified the change as economically significant, with an annual economic impact exceeding $100 million. This suggests that it's a major rule under the Congressional Review Act, which means that it needs to be considered by Congress and the Government Accountability Office, have a public review period, and not take effect for at least 60 days. Those 2 positions are in tension. If this change truly changes little because it merely codifies existing practice, it's hard to square that with classification as a major rule with substantial economic impact. And if it is a significant substantive shift, the lack of advance notice and comment could become a litigation issue in the future. So what else should practitioners and veterans be thinking about right now? We have 3 thoughts. First, Ingram is on appeal to the Federal Circuit. This new rule does not automatically moot that appeal, but it absolutely changes the landscape. The court may still address whether the prior regulatory framework required baseline severity findings. Second, for pending claims where Jones or Ingram arguments were in play, the effective date matters. As of February 17, 2026, arguments for remands to obtain baseline severity opinions may no longer be viable under the amended regulation, so you'll need to reassess strategy accordingly. Third, there's still a 60-day comment period open at regulations.gov under the docket number RIN 2900-AS49. There, the public can voice opinions about this regulation change. If you believe the rule is flawed on the merits or that the procedure used to implement the rule violates the Administrative Procedures Act, comments need to be submitted now. The administrative record will matter if and when this regulation is challenged. For years, we've lived in a world shaped by Jones and its progeny, and requiring examiners to estimate disability without medication was often speculative, a problem that the court recognized in McCarroll. But the fact that a rule was difficult to administer does not automatically make the replacement correct, nor does it insulate the process from judicial review or the APA process. So bottom line here, if you have a pending claim or appeal where this issue is central, this is the moment to reevaluate your arguments and preserve them carefully.